Okay, welcome back. As we indicated, this is the deputy medical examiner. This is the state's witness, and this is in the Daniel Villegas trial. I have a special guest with us in the studio, Ross Kramer from Winston and Strawn, LLP, out of New York, doing white-collar criminal defense and other criminal matters in federal and state court. He's been a super lawyer since 2014 to the president, was a clerk for the United States District Court in the Southern District of New York. Has got a lot of experience and represents some really high-profile clients. And maybe we'll get to the one where you actually represented an attorney general on a perjury charge. Yikes, as a prosecutor, I don't like to hear that. But welcome to the show, Ross.
Thanks for having me.
Okay, so, one thing I just want to talk to our viewers, I always love to give them the inside scoop about what goes on with the nuances of trial law, because you've got to try to be as perfect as possible. This case is being retried. It's old. It's always bad inertia for a prosecutor to try an old case. They don't get better. But now the prosecutor has the medical examiner, and the defense jumps up and stipulates that the medical examiner is an expert, and she basically says, I'm going to quickly tell you about his background. You don't want that. You want that medical examiner to get up there and tell you everything about their expertise. You don't want to get it short-circuited by a stipulation. What are your thoughts?
Well, the judge let it come in. The judge gave her the opportunity to bring up how deep his background is and how experienced he is and all of his education. So I think the jury's still getting a sense of this guy's credibility in his testimony. But I think one of the most interesting parts of the case you brought up before you went to break, the plea that was offered in this case, the Alford plea, right, where he could have maintained his innocence here. He could have stood up and said, I'm innocent, but I'm taking this plea because I think that there's evidence out there that the prosecutors could have put on that could have led to my conviction. And he's still going back to trial here with very severe consequences. It's a pretty amazing choice.
Right. I actually was going to get right back into that plea, so I'm glad that you did that for me. But let me ask you, when you're a criminal defense attorney and you've got a client, and we've had these scenarios, that's looking at pretty much walking away from this, it's a pretty risky maneuver. I got 15 seconds. Thoughts?
It's his choice. It's one of those choices that a client has to make himself. But if I was the defense attorney here, I would have told him, it's pretty crazy. Yeah.
Well, listen, and the bottom line to that, folks, is that the defendant is the one who controls what is going to happen with respect to their future. You can only advise them. It is certainly a risk. Listen, you're at the Law and Crime Network. We are killing it. We'll talk about that a little bit later, right on the other end of the break. Okay, we're back here with Ross Kramer. The pathologist, the medical expert, just testified. They're apparently taking either a break or another witness is coming, but it's a great opportunity. Myself and Ross were talking about this. This was a weird thing that was going on here, both in the manner in which this witness was qualified and the questions that were asked. And I didn't even hear anything about cause and manner of death unless I was trying actively to get into that chat room on the Law and Crime Network. So what were your thoughts about this testimony?
I mean, if I was on the prosecution here, I would have drawn this out for a half hour. This is a 25-year-old murder. Jurors in this jury might not have even been born when this murder happened. You want to make this immediate for them. You want to make them have a visceral reaction. They were showing pictures of the victims in this case, the bullet entry and exit wounds, and they just jumped right past it. They didn't spend enough time really bringing this to life for the jurors, I didn't think. I also didn't think that it necessarily hit home. You know, she was trying to show that bullets came from a certain angle and certain bullets caused death here, but I don't think she tied it together. She was testifying as much as the expert, and it felt very rushed.
I'm going to talk a little nuanced trial law with you.
Yeah.
We were also talking about the idea that she was basically leading that witness, and he is an expert witness who's expected to know how to testify. And while it may not have made a difference to the defense in terms of the ultimate outcome of their defense, I would have been in her face that she was leading the witness just to rattle the prosecutor a little bit. Thoughts?
Yeah, to break up the rhythm of that testimony. In effect, she was testifying, and the judge is going to instruct this jury nothing she says is evidence here. But I would have made this guy testify himself, this medical examiner. I would have put him on the spot. And if you object, I think you can set up the stage to do that.
Yeah, I think that, it's not just about the facts, it's the presentation and the manner in which the case is coming out. It was a little odd to me. Again, I want to try to do a little work with our producers about the cause and manner of death. Maybe they're going to have another witness come up there. So, guys, listen, you are in this Villegas case. This is the third time we're here. Cases do not get better. I'm with Ross Kramer, the Law and Crime Network. People were asking me, what is it that you're talking about that they're killing it? Well, the stats are in, folks. We've had over these network platforms, 5 million impressions in September, and in August, the average watch time of this show is 30 minutes. That's a whopping amount of time. and we've had 2.1 million unique visitors. Woo! We're killing it. That's what I mean by that. We'll be back on the other end of the break. Stay tuned for more Law and Crime. We're watching some playback of witnesses in the Jason Van Dyke case. I've got Ross Kramer with me, a specialist in criminal defense law. We were kind of off record watching these other witnesses, police officers and independent witnesses, that contradict what Van Dyke testified to on the witness stand. Let's take it step by step. As a defense lawyer, you know this case. What's the colloquy going on between you and the client as to whether they're going to take the witness stand in a case like this?
Well, just like we talked about before, with regard to a plea, this is one of the few decisions for a defense lawyer and a defendant where the defendant has to make this decision himself. It has to be counseled by the lawyer, but the defendant's got to make this decision. This was a very hard decision, I'm sure, for him. They had to look, do an audible as it came time for him to testify. If they thought they had any other chance to win this case, they probably would have gone without him testifying. They must have felt like they were behind here and needed to play catch up. But I think his testimony didn't really close that gap. I think this was a very difficult testimony. I don't think his testimony matched up with the facts as the jurors saw them from other witnesses, from the videotape that they have, and I think he had a real credibility problem on the stand.
Yeah, my first boss, when he was teaching me when I was a baby prosecutor, always used to say that juries love to convict from the mouth of the defendant themselves when they take the stand, and it is a huge decision. And you also, as a lawyer, have to gauge how you think your client is going to be able to respond to cross-examination questions.
Yeah, I think in this case, he had a lot of trouble even on direct walking them through. You have a video where it really doesn't look like the victim's arm is coming up. It really doesn't look like he's moving towards the officers, and his testimony was just completely different from what people saw in the video, what the jurors saw in the video, and from what other witnesses testified, that this was something that it wasn't reasonable to use deadly force here because the other officers didn't feel threatened. This was a victim. This was someone who was penned in by a fence and a bunch of cop cars here. There was really no threat to the officers, no immediate threat. This was the only officer who reacted, the only officer who shot. And he was trying to defend that in his testimony. I don't think he did a very good job of it.
Yeah, and actually we're seeing a video right now of the young man in the street after having been shot. And I think also the number of shots is very compelling here. I think that if you were a defense attorney and there were just a couple of rounds, but it just seems so excessive, and I think that that's going to ring very loudly. It's just an emotive fact for the jury.
Yeah, and in his testimony, the defendant said that the reason he fired that second round of shots was because it looked to him like the victim was trying to get up. It doesn't look like that on the video. Not a single other witness said it felt like that to them. So his perception as he testified to it was so far at odds with everything else the jury saw. I think it's going to be very difficult.
Yeah, I mean, they were showing it again. I mean, he is on the ground. It's very difficult to make an argument that you were in fear of your life.
He's no longer a threat.
He's no longer a threat. He's been neutralized, as we would say, and I think he's going to have a tough time. So, prediction, is it going to be it's murder or something less than murder? I think it's going to be something less than murder, an intentional act, but not an outright not guilty.
I think it's definitely not going to be a not guilty here. I'd be very surprised if he was acquitted here. I think you may be right, but I think that this Van Dyke is going to be going away.
Yeah. Well, listen, guys, you are at the Law and Crime Network. This is Ross Kramer that's helping me out here today, and you are in Illinois versus Jason Van Dyke. This has been a massively debated case. He took the stand. We don't think he helped himself. Closing statement should be tomorrow. Let's run to a break, and we're going to be back on the other end. Stay tuned. Ross, you got to love this Law and Crime Network because we are covering it gavel to gavel.
I love you guys.
Yeah, I mean, we're all over. We need guys like you because we're back to the Villegas case. There's another one of those names that's going to be difficult for me for some reason. But in any event, this was a really old case, and I want to go through some procedural history here. We talked earlier about the idea he decided not to take a plea that essentially would have let him out of jail. He wants to clear his name. But this case was overturned because ineffective assistance of counsel all those years later. And when it squirreled its way back into the trial court, they basically, the trial court said that they're going to throw the confession out and some phone conversations that the state alleged between the defendant and his mother implicated him. The state then took the case back to the appeals court, and the appeals court said there was not an abuse of discretion in the judge eliminating that evidence, which took a big hammer away from the prosecutors in this case, which I suspect is the reason why they were willing to offer this deal. So this gives us a lot of meat on the bone to talk about. Evidence rules, they are very consistent with what we have here in federal court 401, 403, relevant evidence. and the exclusion of evidence that may cause confusion to a jury. Can you just briefly explain what relevant evidence is and why a court can actually exclude it in some circumstances?
Yeah, well, relevant evidence is evidence that tends to make a fact that's an issue in the case more or less probable. So it's really broad. I mean, you know, we've had cases, and we've all had cases as lawyers where things were, you know, even borderline. Judges tend to allow relevant evidence in and allow juries to hear it. But there's another rule, and I know we were talking about this off the air, 403, where if the evidence is if certain evidence could be too prejudicial to one side or the other, a judge can keep it out even if it's relevant. I mean, I think the most interesting piece of evidence here is that confession. And, you know, studies and the rules and laws on false confessions and coerced confessions have changed so much from 1993 to today. And you have a lot more people who are willing to testify about the fact that especially young, vulnerable people like a 16-year-old are very susceptible to threats and coercion by law enforcement.
You know, you bring up a great point, and I have seen adults like are accused of something where they are just, I must have done it. Why would somebody accuse me? It turns out they didn't. It's really an amazing psychological thing. But guys, we're back in court on that case, and as we told you, we get to it when the witnesses were there after the break-in. Here we are. Okay, so we're just going to take a little break here. Villegas trial here out of Texas. I got Ross Kramer with me, but I also have another guest, Jerry Gurley from Florida, from the Gurley Law Firm out of Orlando. And boy, what a career in the Navy, a civilian employee for the Orlando Police Department. I love this piece about you. I was reading your bio. You're also a minister, and you became an attorney because you believe that could kind of further that mission. Very faith-based person myself. I love it. Civil rights attorney, criminal defense litigator. Welcome to the show.
Glad to be here.
Okay, so let me just start with you real quick, since you've been patiently waiting for us, Jerry. Is there something odd that you think is going on here with this witness as an attorney and the manner in which the questioning is taking place?
Well, absolutely. And, you know, the thing is, as a defense attorney, I would challenge the witness being allowed to continually refer to his notes and essentially testify based upon his notes. Generally, if you're going to look at your notes, you're going to look at those notes simply to refresh your recollection. I'll give the witness as much time as he or she needs to look at the notes, but once they've had that opportunity, I want them to testify based upon their refreshed recollection.
Yeah, exactly. And Ross and myself are kind of pulling our hair out here for a number of reasons, one of which we both agree with. This could be a very powerful prosecution witness here. And Ross, we were talking about the fact that it doesn't even look like he's been prepped.
Yeah, I mean, trial is not as spontaneous as it appears at the moment. There's supposed to be a lot of behind-the-scenes work to get a witness ready to testify about something, especially something that happened 25 years ago. It kind of looks right here like this is the first time he's thought about it in the last 25 years. I thought they really bombed here, where this could have been a really powerful witness, the guy's own cousin trying to testify about a confession that the defendant made to him at the time.
Yeah, well, listen, Jerry, one other thing, too, and Ross will bring you in on this as well. As we all know in the Law and Crime Network, especially in that chat room, you have people that ask legal questions like, how is this even happening? Well, this powerful witness, this statement that's made to the cousin is hearsay, just so everybody knows, because it's an out-of-court statement used to prove the truth of the matter asserted. That's the strict definition of hearsay. And, Jerry, there's an exception to the hearsay rule, which is a statement against interest. And that is the basis upon which this testimony can come out. But do you agree with me and Ross that this witness looks completely unprepared?
Yeah, I do. And I'm, of course, as a criminal defense attorney, I would love to encounter such a witness. But yes, I mean, and you've noted it, and I would agree with you that there's a lot of preparation that goes into the witness, getting the witness ready for trial. And I tell all of my witnesses, you know, it shouldn't matter, but everything you do and say and how you look and your responses and your posture, everything matters to the jury. You're on stage. And you've got to get it right because the jury is queuing on every possible thing to determine which way to go in this case. And clearly this witness here is coming across as uncertain.
Yeah, absolutely. Listen, we are the Villegas trial. Boy, Ross, I'm going to have a hard time with that for the rest of this case. But we got to throw to a break real quick. And on the other end, we're going to come back with more of this fascinating trial. We got a lot of other stuff on the burner. Folks, get into that chat room, Law and Crime Network, gavel to gavel coverage. We'll be right back. Okay, I got Ross Kramer with me and Jerry Gurley. Guys, I'm losing my mind here. I was going to have a nice, easy day. It's a little hot in the studio. I was going to kind of zen out. But this kind of stuff keeps happening on these trials here at the Law and Crime Network. I have to ask myself, was the questioning of the prosecutor, Ross, we'll start with you because we're losing our minds. Was it direct examination, cross-examination, summation, redirect examination? Was she impeaching? Was she vouching for him? Argumentative? Statements like, gonna let you talk, stopping him from talking, I can only assume. She's basically, she finds his statements incredulous. She's testifying here. What's happening?
Yeah, it's not really fair for you to ask me a question like this because I have no idea what's going on here. She's acting like this is her closing argument. She's giving, 3-minute questions where she's throwing out a whole bunch of facts saying, I'm assuming this is correct. Can you confirm it? This is her own witness. She's supposed to have worked with him and seen what his testimony would be and put him on the stand with questions that allow him to testify, not that give her a vehicle to testify herself.
Right, I agree, and I can hear what's going on in court in my earpiece, so there's nothing really dramatic happening right now in the courtroom, so let's go to you, Jerry. I think that we all found this. At one point, I actually asked the producers, this isn't cross-examination, is it? Or this person is declared as a hostile witness. This was amazing to me. I've never seen anything like it, and the defense just sat there.
It's obvious, and you guys have already been saying this, that she didn't prepare this witness. There essentially seems to be no communication, no chemistry, no understanding between the two, between the prosecutor and this witness. The second thing is that over time, obviously, this witness is now a reluctant witness. He no longer has whatever enthusiasm he had at one time to testify against his family. And that's evident to me. He doesn't want to cooperate at this point.
Yeah, I agree, Ross. That may be, but the fact of the matter is there's a procedure and a manner in which, let's even just step aside from the leading questions. Actually, let's tell the audience the difference between a leading question and a cross-examination question. What are the basics?
Well, a leading question is a question that suggests an answer. So when she says, she makes a statement and it says, isn't that true? You know, she's asking she's supposing the answer before she gives it to the witness. Here, she could just ask the question and get him to say an answer. You know, she could say, what type of weapon was being discussed when you went in there, instead of saying, this was a shotgun, wasn't it?
Right. Now, let's assume that the judge is giving some latitude because there are circumstances where you call a witness, what we typically would refer to as a hostile witness or somebody contrary to your interest, where the judge will give a little more of an openness to ask questions. But on top of all that, she is like summing up in this case saying, I can only assume, comments like, I find this to be incredulous. I mean, that's a statement you may make in summation. You don't make it to a witness on the witness stand.
Well, I'll tell you, she's very lucky that this judge is letting her go on. I have not been in front of a lot of judges that would let this go on. She's very lucky this defense lawyer is not losing his mind in the courtroom. And she will be very lucky at the end of the day if the jury doesn't hold it against her, because they want to hear from witnesses. They don't want to hear from lawyers.
Right. And Jerry, let me just ask you real quick. Would you as a defense lawyer, even if this was not hurting your case, allow this prosecutor to get away with this? Or would you be standing up and saying, oh, let's make it clear, we're going to follow the rules of evidence and the rules of procedure. You're not going to get away with it, even with a witness that's not hurting us, although this witness is hurting?
There are times when I can object, but I don't always object because it's actually helping my cause. Mm-hmm. Now, the problem that the state is going to have here is that on one hand, they're offering this witness as someone who is credible because he has no reason to otherwise normally to testify or naturally to testify against his cousin. But at the same time, what she's now doing is saying, don't trust this witness. So you can't have it both ways. Right. But at this point, you know, I think the defense is benefiting from the testimony of the witness or from what's happening at this point.
Okay, guys, listen, in this case, we now have the cousin that is testifying. There is some legitimacy. I do agree with the fact that he's kind of reluctant to get this information out, which makes his previous statements to the police saying that the defendant confessed perhaps even more valuable than it was in the original trial. Who knows? You're at the Law and Crime Network. I got two great guests. We're covering multiple trials, gavel to gavel. Going to run to a break and come back on the other end with more Law and Crime. Stay tuned. Welcome back to the Law and Crime Network. So we were just at that one trial, the Vegas trial, where they are on break right now for lunch. So that gives us a great opportunity to take my two great guests, Jerry and Ross, and go into the Van Dyke case. That case is almost completed. Tomorrow will be summations. This is the police officer who is now a defendant in a case being accused of murder. That is the charge. You see a picture of him right there. This is back from an incident that occurred on October 20, 2014. The victim, Laquan McDonald. The defendant testified yesterday in his own defense. I talked to Ross about this a little bit earlier, about the value of that testimony and the difficulty in making that decision. And we're going to have an opportunity to listen to a little bit of a clip from the defendant. And I want to get Jerry's take on this as a criminal defense lawyer on the other end. Stay tuned. That's former police officer, now defendant, Van Dyke, on trial for his life, testifying in this murder case. And we talked about this before, Ross, but we have Jerry on now, so I want to kind of ask him his opinion. Talk to us a little bit, Jerry, about this case and your knowledge of it as to the complexity of the decision as to whether to call this police officer to the witness stand, and your thoughts as to whether he helped himself.
Well, yeah, the part that I just saw, quite honestly, was inconclusive, but I do know and did have an opportunity to observe some of his other testimony, and the bottom line is he did not. At times, he seemed to be argumentative and combative. And in terms of making the decision to put a defendant on the stand, that's, as I've heard said earlier, it's the defendant's decision has to be made with advice and counsel, but ultimately, you don't want to do that unless there's no other way to get your theory of the case across. And as was also said, if you think you're losing and this is the one last chance to pull it out, then you put the defendant on the stand. But the decision to do that, of course, is fraught with danger.
Right. And Ross, this kind of, I'm sorry, this kind of gets to Ross's point before. You know, there's a lot of law in favor of police officers, and I know that people don't like to hear that, who have an affirmative obligation, and you did hear him testify to this as a part of his testimony. I have an affirmative obligation to protect the community, that a lot of times defense lawyers can argue the law in these cases, and we all know, and you know this too, Jerry, as a civil rights litigator, and I was one too, that proving police cases for prosecutors on excessive use of force is not easy to get 12 jurors to convict, especially with somebody who had a knife in their hand and had been acting violently previous to this. So I think that he actually really could have hurt himself. I would have at least advised him, do not get on that stand. You may see it a little bit differently.
No, I agree with you. I don't think he helped himself with his testimony. And if he was going to testify, you know, obviously you prepare, again, just like we talked about with other witnesses. As a lawyer, you sit there, you listen to what his proposed testimony would be, and that informs whether you recommend that he go testify. He seems so sure about what happened here. He seems so certain. And his certainty, I think, is weighing against him. If he would have gone in there with the idea that everything was happening so fast, I did the best I could in this rapidly developing situation, I tried my best, I think it would have been better. He's sitting there seeming so sure, and it's just not coming across as credible.
Okay, yeah, listen, guys, excellent commentary by both of you. Greatly appreciate it. We are going over the Van Dyke trial, and so we are really going to kill it on the other end of this break, which will be coming up in a second. But, guys, I want to thank you and ask you, because a lot of people in the chat room are asking us, what do we think the outcome of this is? So I'm going to ask you the difference between murder and lesser included offenses. Let's get to that break so we can discuss that on the other end. Okay, guys, welcome back. We're going to just take a little bit of a turn here, guys. Ross and Jerry, our producers, are so impressed by the questions that are coming on in the Law and Crime chat room here that we're going to try to answer some of those questions because I think it's really relevant in the Van Dyke case. And maybe our producers can actually watch some of the questions while I'm talking to you and throw to some interesting ones. But one of the cases is HJ1 Mad City, I hope I get these handles correctly, who had asked a question. Remember this 16 assault charges that were filed, one for each round? There were 16 shots fired. Was this an attempt to try to either overcharge the case, or did it kind of go like a lead balloon, no pun intended, in here? Was this something that you would have done? Was it overkill? Is the murder charge overkill? Let's start with you, Ross. It's a big topic.
I honestly don't think the murder charge is overkill here because the standard is that he had an intent to cause the death and that he didn't have any reasonable motivation, which in this case would be protecting either himself as an officer or protecting the public. I don't know that in this case a jury would find that he had a reasonable motivation. Yes, there was a danger that could be perceived to other people or to the police officers, but it wasn't, by that video and by other testimony, an immediate danger that would have led a reasonable officer to act the way he did. I think it's appropriate to have that, and the jury will still probably have the opportunity to look at some lesser charges if they think that he didn't act with quite enough malice to be a murderer here.
Okay. Well, listen, by the way, HJ1 Mad City, thank you for the compliment on my jacket. It's my dad's. It's old school. Jerry, let's go back to this concept now. So educate the audience here, kind of consistent with the questions that were being asked by a number of chatters, that at the end of the case, typically, or actually before summations, I should say, the judge will have a charging conference. The judge will basically say, what is the law that we're going to read or not read in this particular case? So I suspect that somebody, and I believe that this would be the law in order to survive appeal, needs to also ask for a lesser included offense, something less than murder, like manslaughter. And appellate courts can sometimes look at it and say, if you don't give lesser included offenses, judge, in other words, if you give the jury an option between not guilty or guilty of the highest charge, you force them to find him guilty. What would you be asking for a defense lawyer on lesser included offenses?
Well, lesser included, it's a risk, it's a gamble, in the sense that, you just have to figure out how strong your defense is. If you have any questions about it, you want to give the jury the opportunity to find your client guilty of something less. Now, in terms of, if I could get back to the question that you asked, Ross, why there were 16 counts of assault, there again, the prosecutor knows that once the jurors get back there, they bargain. And the prosecutor wants to give himself or give the state the opportunity to win either in the highest charge or some lesser charge. So that's why they put those 16 counts of assault. Then I think also just to keep in the forefront of the juror's mind that there were 16 shots, and there has to be an explanation, and to this point there hasn't been a reasonable explanation in terms of why that officer shot 16 times.
Right. Well, 50 Flower asks a question, and this is something that's gone on in the chat room a little bit. And I think it's a fair one because this is really the ultimate factual question. The defendant took the stand. Did you believe him? Did he bring himself to some level of sympathy, or was he not believable, and did he hurt himself emotionally? Ross?
I didn't find his demeanor to be sympathetic. I don't think that he kind of embraced the standard that police officers sometimes use to defend themselves here, which was, I made a split-second decision in a very confusing, very dangerous situation. He testified very calmly that he believed he had a handle on everything. He perceived everything as it was happening and made a logical decision. It looks like by that video and other testimony, that logical decision was not right. And he's not falling back on the fog of war defense that police officers often use to get acquitted.
Well, Jerry, you do civil rights work, and you talk about the fog, concept. I got to be honest. I've gone through the firearms training from the Police Training Commission. There is a lot of fog that goes on in these police shootings. I've handled, and to answer one juror matters questions, have I ever prosecuted a police officer? Yes. And I've also defended police officers. It is not easy. One thing, Jerry, that strikes me, and you've probably been around the block to have seen this, is some of these classes that they do, like Top Gun classes, where cops are making tactical entries into scenarios and are so tunnel visioned in taking out, would you say, the attacker, that somebody comes out of a closet and it's a mock scenario, so it's not even real life, and puts a gun to their head, and at the end they have a videotape and they show it and they say, did anybody approach you during the encounter? And they're so focused, they're like, no, and they tell them, no, there was somebody with a gun, one of our guys. And they look at the video and you see the shock on their faces. It's kind of laughable in the mock scenario, but goes to the point that sometimes the stress is overwhelming. We're seeing it right now on the video here. This scenario is not that kind of scenario. It's just one kid with a bunch of police vehicles. What are your thoughts about all that?
Well, what I see on the video is someone walking away from the officer, walking away from the patrol cars, not in any way menacing the officers. Now, the biggest problem that this officer has is that there were other officers on the scene who essentially perceived the same thing. especially the first officer who called for a taser unit, who followed this individual for 3 blocks, who testified that he did not feel that this individual was threatening him personally, that he made no overt actions toward him, who was on the scene. You know, it's a difficult job that they do, and we don't want to second guess these officers who are put in these difficult situations. However, in this case, we have several officers who were there, and they used their best judgment, and they did not fire their guns one time.
Yeah, I think it's an excellent point that's often brought out, that other officers did not fire the weapons, although the law doesn't require that everyone decide at the same time what is reasonable or not. Some could decide to do it or not do it. But I think, Ross, getting to the point that Jerry's making is not only that, they've got him on the ground and there's a second round of shots fired. And his answer on the witness stand is, well, I thought he may be getting up. I just don't see how he gets around not guilty completely, but I think it's going to be less than murder.
You know, this is another legal term, the totality of the circumstances. You watch that video, you listen to the testimony, there's a fence on one side, there are no pedestrians around there, there are cop cars and police officers everywhere you can see. It doesn't look like there's an imminent danger to anybody. And you know, this may be one of those cases, you know, sometimes you can't second guess an officer. A lot of cases you can. I think this one case you have to.
Right. I mean, I'm just looking in the chat room, Nona's love about just wanting to get away from the cops and how threatening can he be? He's got a knife. But I go back to the point, how threatening can he be after he's been shot a number of times? Hey, guys, you're listening to some excellent commentary from my 2 guests, Ross Kramer, as well as Jerry Gurley. From New York and Florida, respectively, on the Jason Van Dyke trial. Guys, this is a really important thing. The instances of people being shot, I believe, needlessly, even if it's legal, doesn't mean that if you can, that it's right to do. But I predict that there's going to be a conviction. Our chatters have asked us to make some predictions. We did that for you. Thank you for your questions. We're going to go to a break on the Law and Crime Network. We'll be back on the other end. Okay, welcome back. We are talking about this Van Dyke case because the defendant testified. Our excellent producers are giving us an opportunity to go into that chat room. And yes, Tostet and Diana 421, thank you so much for your compliments. This network wants to respond to its audience. You guys ask excellent questions all the time. I greatly appreciate the compliments and really appreciate those questions coming in, because you know what? You're our jury. You're more than just an audience. You're the ones that are giving us an idea of what your perception of the case is. And Ross and Jerry, how many times before I'll start with you, Ross, do you try a case that you don't go out to people like the people in our chat room, regular people that aren't law-related kind of people, tell them the facts of the case, get their opinions about it, and that forms your judgment on how you move forward?
Your viewers here are an invaluable resource. I mean, defendants sometimes pay a ton of money to have these focus groups and have mock trials, bringing in people just to watch a summary of a case. You know, because it's so important to understand what jurors are going to find or key pieces of testimony, what they like, what they don't like. You're getting that here live firsthand.
Yeah, Jerry, what are your thoughts about that? I mean, is that something, and Ross makes a great point, like today more and more you're going to professional organizations that have these focus groups, they call them, I guess, and mock jurors. I've always found, I was involved in only one of them, and that's only because co-counsel wanted to do it. I found it to be very artificial, as opposed to just hanging out with some folks and telling them about the case and getting their thoughts. Do you do that?
I do that informally. I don't ever retain professional services, but I do have some staff members who seem to have a pretty good read in terms of how a jury's going to interpret facts. So I run it by family members, I run it by staff members, and generally speaking, they're on point. Now, I also, when I have a particular client who's not getting it, and I think he or she's going to not do well on the stand, I will allow him or her to go through some type of mock examination. I'll enlist the services of a colleague, and then we'll talk about it.
You know, it's funny. In my career many years ago, I actually was getting paid by people to come in and just they give me a police report and just start beating up on the witness and seeing how they responded to it, typically clients, because that decision, as you said before, Ross, to call a defendant to the stand is probably the most critical, is definitely the most critical decision in my mind that you can make. And as I indicated earlier, there you see a picture of him right now. He's just like slunched over guy. I mean, he gets up there. He was kind of all over the place with regard to his testimony. We don't think he helped his cause at all. But murder? An intentional or knowing act? Like, in other words, are they trying to say that he went out there and it was his intention to kill?
pretty bad body language there. I think that's the first thing you picked up on, and it is something that jurors pick up on. I mean, jurors are watching all the time. They're in that from the minute they walk into that courtroom to the minute they leave. They're looking at that defendant. They're looking at the witnesses, and jurors are very perceptive, and they're really picking up on that. If I was the lawyer, I would have said something to him. Look like you're an innocent guy there. Look, sit the way that you would sit if you were innocent and you were here to fight these charges. Yeah, I mean, I think there'll be lesser included offenses here. I think there'll be reckless homicide. So, it was not that he acted, with a motivation to kill him, but that he acted in a way that could cause death, and he didn't really take into account how reckless that was. But I agree with you from before. I think he's going to be convicted of something here. Yeah,
Jerry, just working off Ross's point right there about watching everything going on in the courtroom. It is true. I feel like my brain has been sucked out of my head when I'm done with a trial because I am perceptive of even things behind me at counsel table. I know that sounds hard for people, but I've watched a lot of lawyers missing nuances, cues to jurors or witnesses being cued, or you got to really be aware, and it's really hard, like a third eye of everything that's going in that courtroom and how you're being perceived and how your client's being perceived is key to Ross's point. Your thoughts?
Yeah, first of all, before we go to trial, I'll tell my clients, look, from the moment that you walk in that door, you're on stage. Until the jury retires to consider the verdict, you're on stage. And so everything that you do, body language, no smacking your lips, no rolling your eyes, no slumping over in your chair, everything matters absolutely. So I would agree with what has been said so far.
But, I'm going to tell you guys a funny thing, and I never knew this about myself until a juror approached me after a trial as a prosecutor and was very nice and very kind in what they had to say. They said, you were pretty stone-faced in a lot of parts of that trial where you were getting hurt, but we knew when you were getting aggravated. And I'm like, oh, my God, what was the body thing? Your ears turn red. I never knew that. People like later when I spoke to my family, they were like, that's true with you. When you're agitated and you're holding it in, your ears get red. This is how perceptive they are, Ross.
You hear stories from people, lawyers who've done this forever, and jurors notice everything. I had a colleague I work with a lot who was trying a case out of town, and he said at the end of a case, a juror came up to him and said, I knew you were an out-of-town lawyer. You wore the same pair of shoes every day. It's just little things that jurors pick up on that you wouldn't even notice, but they really are paying attention.
Hey, this is great. Jerry, listen, the producers are giving us an opportunity to really talk about some real trial strategy stuff, so let's do it. I mean, let's talk about the optics of the courtroom. I listened to a person that was a juror on a death penalty case. A death penalty, pretty serious stuff, it's about as serious as you can get, who said that there was actually discussion in that jury room of how prepared the prosecutor was because they came up with a banker's box with file folders in it and were very organized as opposed to the defense lawyer. So they tended to believe the prosecutor was better prepared, knew the case, was more respectful of them because of that, and they were actually debating that, which clearly is not what the judge tells them to do. Thoughts?
Well, again, I've been a juror. I have a couple of family members been a juror as well. And I know that once the jury gets into the room, they're going to look at the law as they've been instructed by the judge, but then they're going to look at all of these ancillary things that you and I know should not matter, but absolutely do matter. So, yes, it's important that you be mindful of everything that the jurors might possibly perceive that might work for you or against you.
Yeah, so, and to the point of talking about this issue, one more anecdotal stories. How do you tell a defendant to dress? I don't know why this issue comes up a lot, but I literally prosecuted a case one time where the identification was very weak, and the description was the guy was wearing an 8-ball jacket. Remember those jackets for us back in the well, you may not. But you may. It had the big 8-ball on the back, whatever, that had a rip in the front. You cannot make this up, guys. During the trial, the defendant comes into the courtroom with an 8-ball jacket with a rip in the front. And what a commotion I caused by asking the sheriff's officer to seize the defendant and seize the coat. And the defense attorney doesn't know what's going on. And it actually got introduced as evidence. Now, that's a kind of extreme dress code violation, but what are your thoughts about telling a defendant how to appear before that jury dress-wise?
Yeah, I mean, I think you want a defendant to dress like himself. I think one thing jurors are great about is sniffing out a phony, whether it's testimony that they don't think is credible, whether it's a lawyer that they think is grandstanding, whether it's somebody who's sitting at counsel table and laughing inappropriately or treating it like it's not serious, you want a defendant to come in there and dress like himself, dress in things that make him comfortable. If he wears nice suits, wear a nice suit. If he's not a guy if he's a working guy who wears regular suits, wear a regular suit. Don't go out and buy yourself a $5,000 suit for trial. You want to be honest with jurors, and they pick up on it. If you're comfortable and you're yourself, that's the best position you're going to put yourself in.
I agree with you 100%. I know I'm confident that Jerry does too. Now, Jerry, I want to go to something that one of our chatters, Juice6789, said, and I think that this is a really, really important point about law in general. It's kind of philosophical. Juice6789 says that Van Dyke looked deeply disturbed. And, you know, you got to wonder, Jerry, sometimes that they start to make up things in their head and think about what sounds good, and they start to pull themselves away from the truth. I know you've seen that with witnesses, not necessarily to try to deceive the jury, but, you know, obviously he's scared and maybe he is disturbed. What do you think?
Well, I think he looked deeply concerned. And he looked as though he perceived that the trial was not going in his favor. And that's what I picked up, and that's what I saw. So, yes, the jury is seeing that, and they're going to make a judgment or assessment based upon what they see.
And Ross, we were talking about this the other day, and I think it happens in a lot of trials as well, is that a lot of times some of the great detectives I've worked with have said, just because a guy lies or girl lies doesn't mean that they did it. You have to get behind the motivation or the reason for the lie. Tried a case one time, defendant took a stand on a shooting case, and he lied, and I killed him on cross, killed him. When we got out in the hallway, the kid was crying. And the reason he lied about something was that he didn't want to admit with his mother in the courtroom that he was having sexual relations because she was a minister. Maybe, Jerry, I should shoot that one to you, right? She was a minister, Ross, and I said, you know what? You want to recall him so that he says that? Recall the guy, and they didn't. And I think he got hurt because of that. But the point here is that people lie for all sorts of reasons.
You know, it's an interesting instruction that a judge gives a jury when they retire to deliberate. And the instruction is, if you found that a witness lied about something, you could either discount that answer, or you can choose, and it would be a reasonable choice for you to discount everything that witness says. And, you know, the one thing that every lawyer in closing statement will tell the jury to take back into the jury room with them, not necessarily any individual piece of evidence or any individual piece of testimony, but their own personal experiences and their common sense. You deal with people every day. You deal with people who tell you the truth, people who lie, people who tell you something in the middle. Your job as a jury is to go back there and evaluate all these witnesses. You can think, you know, just because he lied to me about something, I'm going to believe other things, or I'm not going to believe him at all. He's a liar. And juries are very, very good at parsing that out.
Yeah, that is exactly right on the money as to what that law is. Excellent point. Jerry, let me ask you just real quick. Your role as a minister and as an attorney, it kind of goes back to those old school counselor of law kind of things. We work very hard in my practice at treating the person first, I say, and then handling their legal situation. I think we actually get more optimal results. We give them reading materials. We set them up with people to help them navigate the difficulty of what they're going through, which, you know, listen, we're human. Van Dyke is a human being. He's he may be held accountable for what he did, but you representing a guy like him, does your minister's role help you in navigating people to the other end of the conclusion of a case? And if so, how?
Well, I mean, I think it certainly gives me a sense that everyone can make a mistake, and we've all fallen short if we're going to go to that scriptural perspective. All have sinned and fallen short, so I can't sit in judgment of him or her. And if I never say that my clients are guilty. What we say is that there are some bad facts. If I'm defending a client who has some bad facts, then I'm going to try to get the best possible outcome. But at the same time, I'm also trying to get that client to see that even if we get beyond this issue, you need to change your ways. Because the more you're involved, the more that you're brought back into the system, the more difficult it becomes in the future going forward to get you out of the situation. So we try to give our clients counsel that this is not where you want to be. This is not what you want to be doing with your life. We're here to help you beyond this bump in the road, but we're not going to be here forever.
I actually wrote that down. You're probably the first person to say something that the client has bad facts instead of saying the normal things we would say. So listen, guys, it's great commentary because I think that what we do as lawyers or what we do as people in any profession that we have is greater than the role that we have. We can all help one another irrespective of the mistakes we made. So I really appreciate that conversation. I think it's important because we change lives as lawyers, and we change lives in every profession that we do, and it's a great platform for us to do that. So guys, listen, we are in the Van Dyke trial. I really appreciate the producers. You can't get this kind of commentary with these kind of guests at any other place in the Law and Crime Network. We got great trials, gavel to gavel coverage. We're killing it on the ratings, as we talked about earlier, and that's because of people like you and the people in our chat room that are making it all happen, the producers and the tech people in the back. This is a Dan Abrams production. We're going to break. We'll be back on the other side. I don't know if this is crazy. Just making a real quick observation before we throw to the next clip of the defendant's testimony. There's a screen with a big X on it in front of the guy. I mean, did you guys see that? What is that?
I didn't notice it because I was just watching how much difficulty he was having answering questions in the way that I'm sure his lawyers told him to answer questions. Coming off there is a little bit hostile and probably not quite the right demeanor for the way he was testifying.
Yeah, Jerry, as a civil rights guy, a criminal defense attorney, I mean, what are you thinking about when you're a guy on an excessive force case, either civilly or on trial for murder for shooting a kid 16 times, gets testy with the prosecutor? I mean, I don't care how agitated you are. What about composure? Isn't this about composure and restraint? Thoughts?
Absolutely. You are making yourself Exhibit A for the prosecutor, and what I'm thinking is that we're losing. That's what I'm thinking.
Yeah, wow, yikes. Okay, so listen, we got a little bit more, one more clip that we're going to show you, and again, if you have any questions, ask them in that chat room. I really appreciate you guys. You're doing a great job. So let's look at that clip again. More of the Jason Van Dyke. He's on trial for his life. He's in that witness stand, and he's trying to convince his jury not to convict him of any offense, much less murder. Let's get to it. Okay, welcome back to the Law and Crime Network. We are in the Van Dyke trial. That is Officer Van Dyke. He's on trial for murder. Ross and Jerry, we were talking earlier about, and there's a lot of chatter in this chat room about what he would or would not be convicted of. Do either of you guys, I'll start with you, Jerry, do you see the possibility at all of a not guilty or an outright hung jury on all of the counts? Can you envision that?
I really can't. I mean, and the one thing that makes that impossible for me to conceive of is the amount of shots. And then the second thing that would cause me to think that that's not going to happen is that he has at least two officers who testified something quite differently than what he testified. And of course, they didn't shoot. And so therefore, that's going to weigh against him. And then I believe there was a third just independent witness who also saw what happened, and he also did not support the officer's rendition of what occurred. So, no, the juror's going to get in there and they're going to bargain, and they're going to probably come up with something lesser than the first-degree murder charge. But I do see a conviction coming out of this.
But Jerry, you also do civil rights work. And there is a refrain out there that many cops are found not guilty for excessive force complaints filed by prosecutors because jurors are uber sympathetic to police officers in encounters. Do you ascribe to that theory?
Well, I know it to be absolutely true as a matter of experience because I've done the civil rights cases in federal court. I had one just 3 years ago where the officer claimed that my client was running toward him, reaching in his waistband, and he saw the butt of the gun. The problem with that was that the officer shot him right in the center of his back. The jury determined that they believed the officer, even though the physical evidence clearly showed otherwise.
And it's to this point that I'm trying to get to, and I'll toss to you, Ross. Here, unlike a civil case, you got to prove the case beyond a reasonable doubt to 12 jurors. Now, he may not have done well on the stand, but that's not the only testimony in this case. And as a defense lawyer, I know you would be saying to yourself, all I need is one. All I need is one to hang, and I at least have a mistrial.
Yeah, I think there's a chance that there'll be a hung jury. I don't see an acquittal here. But, the number of cases that Law and Crime covers that end in a mistrial because you can't get 12 people to agree on anything. You know, your viewers should see that in their regular lives. You try to put 12 strangers together in a room, give them a set of facts. What are the odds they're all going to agree at the end of 2 weeks? But I think in this case it's going to be easier than a lot of other cases because there is a video, because there is corroborating testimony, and because I think there is a defendant who testified for himself who didn't really acquit himself very well.
Right. And so, but Jerry, given the parameters of what we just discussed and the idea that they are sympathetic to police officers, nevertheless, based on the evidence of this case, you don't think this is going to be one of those cases? I mean, we've seen some, Jerry, you talked to me about this, right? We've seen some whopping not guilty or hung juries on cases that you would think were open and shut.
Well, again, the difference between those cases and this case is that you have fellow law enforcement officers that were there on the scene that didn't shoot, that gave testimony that was inconsistent with this officer's testimony, and the amount of shots fired, and as has been emphasized before, shooting him while he's on the ground, incapacitated. And then there's this aspect of the officers doing reports that later don't line up with what the objective facts turn out to be.
Jerry Gurley,
so all that together.
Drop the mic. You killed it, man. That is exactly the summation of the case. I know you have to go. There couldn't be a bigger high note than what you just put it together. You pieced together why I believe there will be a conviction of a lesser included offense. You were a former Navy man, civilian employee, Orlando PD, a minister and attorney. I love that. Civil rights litigator, criminal defense. It was a pleasure having you on, my friend.
My pleasure.
Okay, guys, listen, we are going to stay here with Ross. He's in this hot room with me. We're going to turn the fans on. Then we're going to go to a break. We'll have 3 minutes of cool air, and then we'll be back with more hot talk. See you soon. Okay, welcome back to Law and Crime Network. The fans are off, Ross. So that means we got to start hitting this case and telling our viewers about what's going on here. And we've done a lot with the defendant's testimony, but there were expert witnesses that testified in this case as well. And one of them was a use of force expert and many other experts. So can you just explain before we throw to this clip of a defense expert the difference between a fact witness and an expert witness, and as a lawyer, when do you call an expert witness? Because sometimes they can hurt you.
All right, so a fact witness has to have firsthand knowledge or firsthand perception of what you're talking about. That's a witness who has to have been there or know something about it themselves. An expert witness was not there. An expert witness is someone with specialized or technical knowledge. And the reason for an expert witness is that it allows the jury to better understand a complicated issue. Like in this case, it may be when a police officer is allowed to use force. In the case we looked at before, it may be how autopsies are performed or cause of death. That expert witness is allowed to explain the facts for the jury and is also allowed to give opinions on how things may have happened to a jury.
Right, and you know, experts are allowed to also bring in a lot of, let's just talk about this real quick because I think it's important. They prepare a report. It's required the reports of experts to be exchanged amongst the parties. And there's a real tricky thing with this because experts rely on lots of data that otherwise may not be admissible in the context of an actual court proceeding. But if it's that which is reasonably relied upon by experts in the field, they can rely upon it, and then the judge gives a jury instruction. And this is why I think this is a hot point. I bet it's never been discussed before. The jury instruction tells the jury how they're allowed to use that extraneous evidence that otherwise wouldn't be admissible, not as substantive evidence, but as to the verifiability or credibility of the expert. Can you explain that a little bit?
Yeah, so I mean, it's a difficult balance, and juries have to try to understand what this expert is doing. This expert is not testifying about the facts in the case because he wasn't there, he doesn't understand, but the expert formed an opinion that was based on a number of things that he reviewed, and he's going to give sort of a summary opinion and testimony to help the jury understand this very complicated subject. So the jury is not going to see all of the materials that were behind his opinion, and in fact, the expert may rely on things that are not even admissible in court. But he took all of those things into account in forming this opinion. And now that's not to say that a defense lawyer can't cross-examine him on all those underlying things that he reviewed or that he considered in forming his opinion. And often that's very fertile ground for a defense attorney to cross-examine an expert on.
Right, and if you, I have seen experts explode. I just have a real specialty with experts. I don't know why, but really it's amazing to me how many of them have not been given all of the data in the case by their attorney, and you just basically sew them in by saying it's important for you to have all the data. I mean, certainly you wouldn't want to not have information, more information, better the opinion. You lead them down that road, and once they say yes to that, say, well, I'm just curious because I looked at your file, and I noticed that you didn't have what is marked, S1 for identification. I mean, that's a relevant, go through this. And eventually you put the expert in a space where they're like, hey, I'm not going to put my professional reputation on the line if these guys didn't give me all the information. Have you ever seen it done that way?
Yeah, absolutely. And you know what else is really interesting, I see in a lot of cases? You can go through a whole trial, and the only single witness that got paid to be there is the expert. And I think with juries, a lot of times, they respond to that. And good defense lawyers will ask a question, or prosecutors questioning a defendant's expert witness will say, you're not here out of the goodness of your heart, are you? You got paid to be here. How much did you get paid? Mm-hmm. And they'll go back through other times when an expert witness has testified. Well, here you're testifying for the prosecution, right? And that's because they paid you. Well, 2 months ago, you were testifying for a defendant. And who paid you in that case? Oh, the defendant paid you. So every time you testify, you're getting a check to set up there on the stand and testify the way that side of the case wants you to testify.
Well, listen, Russ, at the Law and Crime Network, we look at ourselves as an educational network, or at least I look at it that way, and I'm sure they do as well. And one of the things that I find really fascinating about the network is we can give practice points to people. And one of the other ones, you kind of alluded to it, is get that expert's CV, their curriculum vitae, go through the articles they've written, previous reports they've authored, because you can hit them over the head like a hammer sometimes that they contradict themselves literally from, as you've noted, whether they're testifying for the defense or the prosecution. And not only can you make them look terrible and eradicate their testimony, you can make the adversary's case and the adversary themselves get hurt with that as well.
No, absolutely. I mean, you'd be surprised how many times these are sort of what's called in the industry, witnesses for hire in a way. So you can get their transcripts from when they've testified at trials a year ago, 2 years ago, 3 years ago in similar kind of cases, and their testimony is not always consistent. And that's really ripe ground for cross-examination.
Excellent. Listen, that's why we love having guests like you, because you obviously do it. You know what we're talking about, and you're helping us educate our viewers. Guys, you're at the Law and Crime Network. This is the Van Dyke trial. So we've been talking about expert testimony. Let's look at one of those defense expert witnesses, and it'll be able to show that they're taking certain facts and allowed to offer an opinion on those facts, which other fact witnesses are not allowed to do. Let's check it out. Okay, well, Ross, we were talking all about expert witnesses and how you qualify. I think they did a nice job qualifying the guy. What are your thoughts about that based on our previous conversation in terms of his opinion?
I know a lot of people who have watched that video, the shooting video here, and I haven't heard from a single person or read an article where someone, the first time they watched that, thought that shooting looked justified. I can understand there could be arguments brought up about how, upon review, upon how speaking with the defendant in this case, he could change his mind. I didn't particularly like this testimony. I thought what he was saying is there could be problems with a video. You should disregard what your eyes and ears see here. The video wasn't quite right. The lighting may not have been honest. There was a really close proximity here. Jurors are watching that video. There's not a really close proximity here. This is the kind of witness that a defense has to put up at this case, I think. But I think that jurors are going to take this back into the jury room and say that expert's testimony was paid for, and it feels like a stretch.
I want to just respectfully differ on one little point, and I agree with the overall assessment that you made, but I think that these use of force experts are important in terms of how the officers are trained. And like I said before, I went through that training because I was always curious as a civil rights litigator, as a former assistant prosecutor, criminal defense attorney. Became prosecutor. I want to know what training they got. There's actually a scenario they put up there about a person with a knife on what they call the FATS machine, which was something that simulated, events, and how somebody at a distance of 20 feet, or I believe 25 feet, it was something of that nature, can close the gap in 2 and 3 steps. And, essentially letting them know that even though they may not be on top of you at that point in time, they still represent a danger. So that part, I think, could be beneficial to the cop. But what I found interesting with this expert is he had to call the defendant, the cop, on the phone in order to justify the second volley of shots, which is when he was on the ground. And if I were the prosecutor in this case, that's where I'd be focusing my attention, because you knew when you saw it, you needed additional information because it looked no bueno to you. And we can see a copy of it right now. Let's look at it. Boom, 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 boom. He's down. Boom, boom, boom. Still shooting.
He's not trying to get up.
He's not trying to get up.
Yeah, no, I think the first part of what you talked about would be very, very helpful. And in fact, I may have put on a witness who would say how difficult a police officer's job is when confronted with an armed assailant, and just talk about that instead of the defendant. I may have had that guy just talk instead of Van Dyke, and then a closing argument. The defense lawyer can use all of that information, but I didn't like this opinion.
Yeah, I agree with you completely, and it is a legal case, too. We're going to go to a break, and on the other end of that, we're going to come back as Ross has given us some awesome commentary about how we would have handled the case. We'll be back. Welcome back to Law and Crime Network. We're breaking down the Van Dyke trial, and Ross, we're talking about this expert, use of force expert, for the defense in the case, and we're basically breaking it up between two volleys of shots, one when he was standing and when he was down. And you can see really powerfully how the expert, I think, does a good job at talking about the closeness in proximity, which is consistent with the training that I had, that what led up to the confrontation. In fact, he's walking away. Now listen to Officer Commands. Had the previous violent encounter. He's got a knife. He pops a tire of a police car. And the fact that he's carrying a deadly weapon. So far, so good. And as you've indicated, maybe you just want to rely on the expert as opposed to the defendant testifying. But then the expert's got to call on the second volley of shots at the defendant in order to explain that. And so you think that he's going to get hurt with respect to mainly what's going on once he's on the ground, or do you think the whole thing is unjustified?
I think the whole thing's unjustified, and I think that's where he's going to lose. I mean, I think I said this before, but you look at the totality of the circumstances. You look at the surroundings here. A fence on one side, cop cars surrounding him, no civilians, the other police officers acting calmly. It doesn't feel like things were escalated to the point where it was justified to use deadly force there. And I think that's really going to be the bottom line that the jury's looking at. I think that the extra shots after the guy's already down only reinforce the intent of this officer to cause a death here, as opposed to just diffuse a situation, which was really his job.
Okay, so our producers have for us the continuing clip of this expert witness, and I'm just interested to see how he's going to dance around those shots fired when he was on the floor. Because, bottom line is, on the floor as they call it, right? The bottom line here is that they're trying to prove the prosecutor's a criminal case, and I bet you they're saying to themselves in summation, even if we can't get anything for what happened when he was standing, we're certainly going to get something for when he was down on the ground. Let's check it out. Okay, so this is cross-examination of the defense use of force expert. Let's talk about demonstrations in the courtroom. Prosecutor grabs a knife, puts it down by his side with his suit on and the antiseptic nature of the courtroom, and a witness in a witness box, and says, "Am I a threat? Would you shoot and kill me?" Effective or not, Ross?
I didn't like it there from that attorney, from the prosecutor. I would have liked it if I was on the other side, because it's a very aggressive move in front of the jury, close to the jury. They're seeing an armed, fully grown man standing there only a few feet away. I would think after that demonstration, they might say, "Oh, I was a little nervous about having him there." And that's exactly the point. That's exactly the opposite of the point that prosecutor wanted to make. I'm not sure I would have done that demo right there.
Yeah, I agree with you 100%. And that visuals like that can really be seared into a juror's mind. Not to mention the fact, of course, it's in a sterile environment. Nobody ultimately was threatened, but the threat still, like you said, is palpable to them. And that's not this case. As he indicated, you hear some of the things I was talking about before. I don't think he's articulating it very well, but there was a previous violent encounter. There was an assault, and we were laughing about it, on the police car. But nevertheless, it was a violent action. There was a failure to listen to commands. He's armed with a knife. So if I were the defense lawyer, I'd say if you felt that was ominous when the prosecutor did that in this courtroom with a suit and tie on in order to make a point to you, ladies and gentlemen, can you imagine how the officer felt that night when he was at the scene? Thoughts?
Yeah, absolutely. I mean, I wish that some of these lawyers would come and talk to us before they went and tried this stuff in the courtroom for the first time. Because I thought that was the wrong vibe to set in the courtroom if you were the prosecutor. It was a vibe of menace and danger. And I think that's the opposite of what they were trying to set up. I think they wanted to set up the idea that this was not an imminent danger to anybody. When he was standing there with that knife and a juror sitting in the jury box, they could have thought otherwise.
Right. I mean, this is one of the reasons, too, when we're prosecuting cases and we have an ominous-looking weapon, like a lock blade or something like that. You see the defendant right there, kind of slouched over there, or a gun. You want to have that evidence out in front of the jury, and as close to the jury as the judge is going to allow you to do. In the old days, you should just be able to give it to them. Now, I guess because of some episodes and things that have happened inside the jury room and in the jury box, they're more cautious about weapons. But we know it's ominous to the jury.
Yeah, I agree with you. I think this was a very difficult demonstrative, and we'll see if it comes back to bite him in the end.
Right. And let's not forget, too, and it's one of the last point, is that we all got to look at what law is going to be charged here, because officers do have a much greater latitude to use deadly force. But again, I don't think he's going to possibly get past the shots on the ground, but I say not murder.
All right. I say that there's a good chance that there could be a murder verdict here. I really think so. I just think when you look at the whole situation out on that street, that I don't see a reason why it was justified for a police officer to use deadly force at the moment that he did. It may have escalated. There may have been a point that he could. I don't think it was there.
Okay, Ross Kramer, I want to thank you for all the great, excellent legal analysis. Ladies and gentlemen, it has been, again, an honor and a privilege to be on the Law and Crime Network hosting. To all of our people in the chat room that were asking those excellent questions, thank you so much, and for all the compliments that you gave to both of us here on the show today, to our producers and the technicians and everybody that makes this happen. We thank you so much. Only this network is covering this gavel to gavel. No wonder we're killing it in terms of viewership. I'll be back next week from 12 to 3 on Monday and Wednesday. Law and Crime Network, gavel to gavel coverage. Be blessed.